Imagine this. You've waited years. You've done everything right. You filed your I-130 petition for your spouse, your parent, your child, someone you love more than anything, and you finally got that approval notice in the mail. You thought the hard part was over. But now, out of nowhere, USCIS announces massive changes to the I-130 family-based immigration process, and they're going into effect in just a few months, from January 2026. These aren't small tweaks. These are big, fundamental changes that could completely alter how your family's immigration case moves forward, or whether it moves forward at all. And if you don't act now, if you don't understand what's coming, you could lose precious time, miss critical deadlines, or worse, put your loved one's chance of staying in the United States in serious jeopardy. This isn't fear-mongering. This is fact. This is real. And if you're watching this video, there's a good chance you or someone you love is already in the immigration system, waiting on a case, hoping for a green card, praying for a future together in the United States. So listen closely, because what I'm about to tell you could change everything. Let me be very clear from the start. The I-130 petition is the foundation of almost every family-based immigration case in the United States. It's the very first step. You file it with USCIS when you're a U.S. citizen or lawful permanent resident trying to bring a close family member to live with you here permanently. Whether it's your spouse, your unmarried children under 21, your parents, or your siblings, the I-130 is how you start the process. Once it's approved, your loved one can then move on to the next steps, like applying for a green card, either here in the U.S. or abroad through consular processing. But if that first step, the I-130, is disrupted, delayed, or changed in a way you don't understand, the whole process can fall apart. And now, starting January 2026, USCIS is rolling out major procedural and possibly policy-level changes to how the I-130 is processed. We don't yet have every detail, but based on official announcements, internal memos, and statements from USCIS leadership, we know these changes are designed to streamline processing, but not necessarily to make it faster or easier for you. In fact, some of these changes may add layers of complexity, require more documentation, introduce new eligibility scrutiny, and create new risks for applicants who aren't fully prepared. Now, let's break this down, because you need to understand exactly what's happening, why it matters, and, most importantly, what you need to do right now to protect your case and your family's future. First, let's talk about why USCIS is making these changes in the first place. Over the past several years, USCIS has been under immense pressure. Backlogs have hit record levels. Processing times for even the most straightforward I-130 petitions have stretched from months into years. The agency is drowning in applications, especially for family-based immigration, which still makes up the majority of all green card pathways in the United States. Tens of thousands of cases are stuck in limbo. Officers are overwhelmed. And meanwhile, politicians, lawmakers, and even the American public are calling for reform, efficiency, and accountability. So USCIS is responding. But their idea of responding may not align with your idea of fairness, speed, or protection. The agency has announced that starting in January 2026, they will begin implementing a new case processing framework for Form I-130, Petition for Alien Relative. This includes updated internal review procedures, new eligibility criteria that could affect certain relationships, and, most concerning to many of you, a potential shift toward more restrictive interpretations of what qualifies as a valid family relationship. Now, I know that sounds alarming. Let me be clear. U.S. immigration law still recognizes spouses, children, parents, and siblings as eligible family members for immigration purposes. That hasn't changed. But USCIS has recently shown a pattern of taking a harder line on documentation, proof of relationships, and even intent. We've seen an increase in request for evidence, RFEs, and notices of intent to deny NOIDs for I-130 cases where the evidence of a bona fide marriage or family tie wasn't strong enough. And with these upcoming changes, that trend is likely to continue, or get worse. One of the most significant changes we expect in January 2026 is a new digital filing and tracking system that will overhaul how your I-130 case is managed from start to finish. USCIS has been working on modernizing its systems for years, and this new platform is designed to replace outdated case management tools with a more automated, data-driven approach. On the surface, that might sound like a good thing. After all, who wouldn't want faster updates, better communication, and more transparency? But the reality is more complicated. With automation comes less human oversight. And when you're dealing with something as deeply personal and nuanced as proving a family relationship, especially in cases involving marriage, blended families, or cultural differences, that lack of human judgment can lead to wrongful denials, delays, and misunderstandings. Already, many of you have experienced the frustration of submitting a perfectly valid petition, only to receive an RFE asking for documents you thought were already clear, or worse, getting a denial letter that doesn't reflect the full story of your case. And here's the part that should make you sit up and pay attention. USCIS is also considering stricter timelines for responding to requests and providing evidence. Under the new system, if you don't respond to an RFE or NOID within the exact time frame they give you, usually 30 to 60 days, sometimes less, your case could be denied automatically. No appeals, no second chances, just gone. And once your I-130 is denied, your loved one's path to a green card is blocked, and in some cases, they could even be put at risk of deportation if they're no longer maintaining a valid immigration status. That's why it's absolutely critical that you stay on top of your case status. You need to know how to check your I-130 case online using the USCIS Case Status Online tool. Go to uscis.gov, Case Status, enter your receipt number, and check regularly. Don't wait for USCIS to contact you. Don't assume that just because you filed everything correctly, your case is moving smoothly. Many of you have told me, but I filed my I-130 months ago and haven't heard anything. That silence? It's dangerous. Because in immigration, silence often means delay. And delay can become denial if you're not careful. You need to take control. Sign up for case status alerts. Download your receipt notice and keep it somewhere safe. Write down your receipt number. Know your filing date. And if you haven't received any updates within the normal processing time, check the latest USCIS processing times tool on their website. That tool tells you how long it typically takes USCIS to process an I-130 petition based on the office where you filed. If your case is taking significantly longer than the posted processing time, you have the right to file a case inquiry or even a mandamus lawsuit in extreme situations, but that's something you should only do with the help of an experienced immigration attorney. Now, let's talk about another major area of concern: document requirements. USCIS has been steadily increasing the amount of evidence they require to prove a valid family relationship. For marriage-based I-130 petitions, that means not just a marriage certificate, but joint bank accounts, lease agreements, utility bills, photos, affidavits from friends and family, travel records, and even social media activity in some cases. And if you're filing for a sibling or a parent, the documentation requirements can be even more complex. Starting in January 2026, we expect USCIS to expand the types of evidence they consider mandatory and possibly introduce new forms or supplemental questions designed to dig deeper into the nature of your relationship. That means you need to be proactive. Don't wait until you get an RFE to start gathering documents. Start now. Build the strongest possible case from day one. Talk to an immigration attorney if you're not sure what's required, because the difference between a strong I-130 petition and a weak one can mean months or even years in processing time, not to mention the risk of denial. And here's something else you need to know. Fraud detection is at an all-time high. USCIS has created specialized units to investigate suspicious petitions, especially those that seem to be based on fake marriages or fabricated family ties. If your case raises any red flags, even unintentionally, it could be flagged for additional review, sent to a Fraud Detection and National Security Directorate (FDNS) officer, or even referred for an in-person interview. And if you're not prepared for that interview, if you can't clearly explain your relationship or provide consistent answers, your case could be denied on the spot. That's why it's so important to be honest, thorough, and consistent in everything you submit. Don't cut corners. Don't rely on translations that aren't certified. Don't submit blurry copies or incomplete forms. Double-check everything. And if something doesn't make sense, ask for help, because the stakes are just too high to do this alone. Now let's talk about advanced parole and travel risks. I know many of you are in the process of waiting for your green card or adjusting status, and you might be tempted to travel outside the United States. Maybe it's an emergency, maybe it's a family event. But if you file an I-130 and you're not a U.S. citizen or green card holder with the right to travel, you need to be extremely careful. Traveling without advance parole can result in being denied re-entry, or worse, being considered to have abandoned your immigration application. And with the new changes coming in 2026, USCIS may tighten these rules even further. We've already seen increased scrutiny at ports of entry and more denials of re-entry for people who appear to have questionable immigration intent. So if you're thinking about traveling, talk to an immigration attorney first. Don't risk your status. Don't risk your future. Because once you're outside the U.S., getting back in can be far more difficult than you realize. Finally, I want to address the emotional side of all this. Immigration is not just about paperwork. It's about people. It's about families. It's about love, sacrifice, and the dream of a better life. And when you're stuck in a system that feels slow, confusing, and unfair, it's easy to feel hopeless. But you are not alone. There are resources. There are people who can help. And the most important thing you can do right now is stay informed. Because knowledge is power. And in immigration, being informed can mean the difference between staying together and being separated. Between getting a green card and facing deportation. Between achieving the American dream and watching it slip away. So here's what I need you to do right now. Hit that like button if this video helped you. Subscribe to Immigration News Today so you never miss an update. Turn on notifications so you're the first to know when new changes happen. And leave a comment below. Tell me what you're going through, what you're worried about, what you want us to cover next. Because your voice matters. Your story matters. And together, we can navigate this system, protect your rights, and fight for the future you deserve. Thank you for watching. Stay safe, stay strong, and stay informed. See you in the next video.